Alright guys, let's talk about the dispute settlement process at the WTO. The General Council of the WTO, seated at Geneva, functions as the dispute settlement body. WTO sets rules for smooth functioning of trade among the member countries. But some countries break rules for their own benefit and other countries suffer. The country which breaks rules is called as the erring country, and the aggrieved country which approaches the WTO for resolution is called as the complainant country. Suppose a country makes its trade policies which are in violation of the WTO rules, then the first step taken by the aggrieved country is to request for consultation at the WTO. This initiates the dispute settlement process at the WTO. The first stage of dispute resolution is bilateral consultation. So WTO asks both the erring and complainant parties to hold formal negotiations and resolve the disputes on their own. The parties are expected to discuss the matters and arrive at a satisfactory solution that is acceptable to both the sides. But if the bilateral consultations fail to find a solution within 60 days, then the complainant country can request for adjudication by a panel of the dispute settlement body. The DSB, upon hearing representations by both sides, delivers a verdict. This verdict can be further challenged in the appellate body. After the final verdict of the appellate body, the erring nation is directed to make changes in its laws and comply with the WTO rules within a reasonable time. But the important thing to note here is that WTO has no enforcement powers, so the erring country may or may not make changes to its laws. So how is this problem solved? In case if the erring country fails to comply with WTO rules, then the complainant country is allowed by the WTO to take cross-retaliatory measures.